Hi, I'm Shannon Keith, and I am an animal rights attorney based out of Los Angeles, California. And I do a lot of, well, basically my life is encompassed with animal issues. I have my own practice. I have a nonprofit organization wherein we rescue animals that are on death row, and also the nonprofit produces documentaries. The last documentary was called Behind the Mask, about the Animal Liberation Front. And one thing that Lauren sort of mentioned is being an attorney is such a great tool that we have, because for some reason it gives some of us instant credibility. So for example, when I made Behind the Mask, I talk about the Animal Liberation Front in a positive way. I talk about the necessity to break unjust laws. And I strongly believe that if it were somebody else, a non-attorney, saying those things, it wouldn't have the impact that it did. And many people have told me that as well, that, well, she's an attorney, so she must know what she's talking about. So it kind of gives us the pass to do the things that we really feel passionate about and want to do. When I got into animal rights law, I was really focusing on civil litigation. I wasn't per se an activist at the time. I wanted to change the status of animals in society. And when I became an attorney, I met several activists in Los Angeles who sort of threw me into that world. And it was really exciting. I started doing what's called legal observing, going to protests and being a liaison between the activists and the police, and just sort of flying by the seat of my pants and trying to get people, protect people's rights and make sure that they weren't going to get arrested, or if they were, that we were all on the same page, and we did jail support and things like that. One of the issues, though, that sort of arose while I was doing this, and this became a gray area, and it's something that I want you all to think about in representing activists, especially when you're there and you're someone who is active, like on the front lines, or you're a legal observer, or you're actually involved in the protest yourself, is that a conflict can arise when you're there. There were several protests where I was involved as a legal observer, and my clients were arrested. And I faced the dilemma of, do I represent this person because I was essentially a witness? And if I'm a witness, then I can be called to the stand to testify, and that creates a conflict of interest, or it can create a conflict of interest, not always. And I did deal with that issue, particularly in one case a few years ago in Beverly Hills. And what happened was that there were a few people videotaping the event, and I was a legal observer. In fact, I don't know how the prosecutor recognized me, because I was wearing sunglasses and a hat and everything else. But about halfway through the process, he said, he called me up and said, Shannon, I was watching the videotape carefully. I see that you were there. You're going to be subpoenaed, blah, blah, blah. And I was concerned because I didn't know what that would entail. And what happened was, I guess he tried to subpoena me, but I was never available. And and at the end of the day, someone else stepped in and resolved the case. But that is something to just sort of keep in mind, when you're doing these kind of things. Another great thing and an exciting thing about being an activist attorney and representing activists is, like, Lauren was talking about as well, is that they care so much about the cause, and hopefully you care as well, and it gives you that energy and that passion to move forward. I have a funny story with a case in LA. I was representing, actually what we did in terms of like joint representation, representing a group of people, I was the only private attorney, and then there were two defendants who were representing themselves, and then the other 2 or 3 had public defenders. And that was a great way to mix it up. Essentially, not really for me, because I was doing all the work, but what was great about having a couple of the activists representing themselves is that they could get away with a lot of things that I couldn't as an attorney, right? Like, say things that they really weren't supposed to say, and it's like, oh, sorry, Your Honor, like, I didn't know I was supposed to say that, you know, but get it in, you know? And what I've noticed is judges are very lenient, especially with these political activists. They seem to be like, okay, all right, you didn't know any better. Okay, you got it in, I know that that was your point. But I had a case, and what I always tell my clients is, please, if you're doing this to make a statement, then follow through. Don't just hire me and have me make all of the appearances and do all the work. You're in this with me, and you're going to do the work with me, and you're going to show up and go to court. And with the clients that I had that have actually done that, we've been successful. I noticed that judges really respect a case more and respect the defendants more when they show up. So we had this case, I mean, it was undisputed. My clients were guilty, and it was on videotape. It was just, there was really no way around it. So we were, you know, making a political case out of it, and every single one of the people showed up every single time, and we had maybe 12 court appearances, and these are people that came from other states as well. I mean, they drove down to come and do a 5-minute court appearance, and one day the judge said, you know, I've never had a case where all of the defendants show up for every single court appearance, and I want to say that I respect you all, and it's because of people like you that we have the freedoms that we have today, because he knew about the case. It was an animal rights protest. And at the end of the day, what ended up happening, and we're talking on videotape, people vandalizing equipment, smashing computers, a lot of illegal activity going on. The prosecutor was just, they're going to prison. You know, that was it. And we're pushing and pushing. And at the end of the day, the judge said, I'm actually going to step in and assert my authority and say that I just, if you all want to plead, because the only thing that they would do was plead to infractions with community service at the nonprofit of their choice. So what the judge said was, I'm stepping in and I'm giving you all disturbing the peace infractions, and just, you know, do community service at an animal rights organization. Bye-bye, thank you. And the prosecutor was like up in arms. He was like insane, like, no way, you know, you're abusing your discretion and everything else. But it was great, and I don't think he would have done that had he not had some, you know, serious respect for those people that showed up and cared about their case. And speaking of community service, a great thing about having a nonprofit organization is that those people that do have to do community service can do it for that nonprofit. So because I have one, usually my clients can do community service with my nonprofit. So it's great for me, and it also works really well when I'm working for free because I'm also struggling. You know, I only do animal rights law, so it's not an easy life. But if they can then turn around and help me with, you know,
filing.
Yeah, anything, that's great. You know, so that's something to think about as well. It's getting into the climate that we're in. You know, Will and Lauren talked about with the Animal Enterprise Protection Act and now the Animal Enterprise Terrorism Act. It is a scary time, but you know, I haven't seen it impact my clients really that much. Yes, it seems that people are slightly more fearful in general, but when it comes to something that people feel passionate about, they're going all the way, and it's exciting to see that, and I hope that you know, remains that way. But in terms of our freedoms being completely taken away, and privilege, like Lauren was talking about, don't ever assume that anything's privileged. You know, a phone conversation with your client or email communications. I personally had that experience. And I have to say, yes, it's scary, but I learned my lesson. Nothing's privileged. Nothing is sacred anymore. And, you know, the attorney-client privilege is supposed to be one of the most sacred privileges that we have. I was representing Shaq, Stop Huntington Animal Cruelty, and Kevin Jonas a few years back in a civil case in San Diego, California. And Kevin and I also happened to be friends, but we had several conversations over the phone about the case. And what happened was, fast forward a few years, and you know, he's federally indicted, and the whole federal case is starting, and they're going through the discovery process, and FBI documents were unsealed, and I see that my phone conversations with my client Kevin were tapped. So they go through this entire thing about, okay, we know that Shannon Keith is an attorney, so we need to be careful about attorney-client privilege. So, because what happened was they had pen registers on my phone, but they could only tap Kevin's phone. So when they have a conversation, we need to be careful. So essentially what they did was they would have people listening in on the conversation. I don't know how many people, let's say a few. Then it would be recorded. That conversation would then go to agents or whomever who would transcribe that conversation. And then that transcription would go to specialists who then decided what portions of the conversation were privileged and what portions weren't. So at this point, I mean, I would venture to guess at least 15 people have listened to an attorney-client privilege conversation. So beware. Yeah, it's a really, it's a scary thing. And same thing with email and PGP. I used to have PGP, and that's how I communicated with a lot of my clients. And during the Shaq trial, the federal trial, the government, were you there, Will, when they put up the PGP key rings? Yeah, they put it up, right, and they said, these are all the people that are, you know,
Nobody back there knows anything about what you're talking about, right. PGP. All of us are looking at each other like,
I'm sorry.
Thank you.
Sorry, thanks for saying that. PGP stands for Pretty Good Privacy. And what it is it's a program that you can download that encrypts your email, and you can also use it to encrypt your entire hard drive. So what happens is that you have a private key, what's called a key, and a public key. And let's say I want to send an email to Lauren, and we want to have our emails encrypted. I send her my key, and she sends me hers, and they get put into a key ring. And then we type in our passcode after we write the email, and it encrypts the email so that nobody else can read it. Just Lauren and I can read it. Did that clear it up? Okay.
What is it again?
PGP, Pretty Good Privacy. And I don't, can you still get it for free?
Yeah.
Yeah, you can still get it, okay. So anyway, during the federal trial, the government had listed all the people that were part of this secure key ring. You know, because I would have in my file, let's say, you know, Will and Lauren and Kevin and, you know, other activists, everyone that feels that, yes, it's necessary because our privacy is being invaded. And essentially they were prejudicing, you know, the court to believe that just because activists and attorneys are being careful about their privacy, you know, they must be guilty because they're hiding, you know, what they're talking about.
And just a side note, you know, in my environmental cases, when I have co-counsel, like if 3 organizations, staff attorneys are working on a case, we PGP everything because of industry. hacking into our emails and getting our briefs and stuff before we file them. So PGP is not just something that radicals use to hide stuff. It's a legitimate resource for lawyers.
Yeah, thanks for that. Yeah, definitely. Yeah.
Well, since it says pretty good, how easy is it to pass?
Well,
There've been,
go ahead.
There's
Yeah.
been a few issues coming up with international travel, and people have coming into the country, and at the gates, FBI agents asking activists and demanding that they decrypt their hard drives, and there have been a couple of court cases coming about this. One of them was a guy who had child pornography on his computer. So they're trying to roll back a lot of these or attack these software programs, in part because the FBI have a few statements buried in here somewhere that they haven't had very good luck hacking into it. At the same time, I think Lauren's touched on this, as so Shannon, it should never be assumed in PGP, pretty good privacy is meant as a joke, even though it's like 128-point encryption, and it's like the dominant program in the world for email encryption, that nothing is foolproof. So I think that's the caveat.
But the simple answer is, unless somebody gives up their side of the code, you know, if the feds get a computer and someone consents to open it up, it's open. But unlike a lot of other encryption software, you know, the feds mandate that they have a backdoor way to get into most encryption programs, mainstream encryption programs, which means if they want in, they have this backdoor in. PGP is one of the only programs that I'm aware of that has not given the feds that backdoor access, which is why it's free and why it's constantly changing too.
Yeah, so definitely I'll look into that. This is like a PSA. All right. One thing I wanted to mention, is a little difficult because I'm from California, so I have the ethics rules for California, and I looked at some of the ethics rules for Washington, but maybe you have something similar here, but this is my favorite rule ever. It's on the rules of professional conduct. It's called advising the violation of law. A member shall not advise the violation of any law, rule, or ruling of a tribunal unless the member believes in good faith that such law, rule, or ruling is invalid. A member may take appropriate steps in good faith to test the validity of any law, rule, or ruling of a tribunal. I love that. If I don't agree with something, then I can test it, and that's pretty broad, don't you think? Right? I can advise my clients to test that. That's legal, as long as I'm doing it in good faith, right? I think, was it Will? You were talking about masks? You know, that's something that, that comes up a lot. Same thing with sound ordinances, trespassing. You know, we have all these local ordinances in place, and I'm sure that you do here as well, that infringe on the constitutional rights of these protesters and activists, and you know, those should be tested. Why not, right? If they're going to do it anyway. Anyway, you might have something similar in your jurisdiction, so I suggest looking it up because it's great. And finally, I just wanted to talk about being an attorney and that being your form of activism as well. I know I sort of already did that, but what's great about being in the courtroom is that you have a captive audience. Everyone's got to sit there and they've got to listen to what you're going to say. And you're free to say what you want. You know, if a judge doesn't like it, they're going to tell you they don't like it before they issue sanctions, usually.
Haul you off to jail.
And especially when you've got a jury trial, you know, it's exciting. You can really espouse your cause. And I have to disagree with someone who was speaking before about, you know, we have to deal with what we have already. I completely disagree. I see being an attorney also as a form of activism. When I file my briefs, I put in the language that I think is appropriate. I don't use typical everyday language like pet. I've never used the word pet. I use companion animal. I don't use things that I don't agree with, and I don't care if that's how it's referred to in the case. There's great analogies that we can make, and I see it as educating the judge and educating the jury and educating everybody else that's in there. And that's the only way that we're going to make change. We can't take a case and say, well, this is what we have to work with only, so we're kind of stuck and let's just take it as far as we can. No, our job as activists, and especially speaking for the animals, is to push the envelope, take it that step further. We went to law school. Most of us are still paying our debts. And, why not? This is what we did it for. And the animals deserve that. They deserve us fighting for them. Thank you.
So we've got 5 minutes or so for questions. If anyone has any? Yeah.
I'm wondering, for those of us who are still in law school, what classes or things you would suggest taking, like maybe sort of advanced civil procedure, federal procedure, evidence, like what you've actually encountered that you wish you maybe had some familiarity with?
Well, you can't ever get enough evidence. Any trial practice classes, even if it's working for a public defense clinic, any time that you can get into court and try out your trial skills, I think is really helpful. I also think any APA class, Administrative Procedures Act class, like rule-making classes, getting those fundamentals under your belt is good. And for me, in my practice, just take as much con law as you possibly can because it underlies both criminal and civil rights litigation.
And criminal procedure as well. Criminal procedure is key.
In the back?
Yeah, I may be one of the only people in the room who acts as a prosecutor. Prosecutes protesters, but spent the first 10 years or so of my career defending protesters. And I got to tell you, in the last 10 years or so, what's happened, at least in Seattle, King County, Washington State, is they're protesters. The message has started to get completely lost. Whether you're animal rights protesters, WTO protesters, or whatever you are, the courts and the public have started to see them as just another protester case. So little things like, I can't remember who spoke because it's hard to see and hear back here. So little things like educating about the term companion animal versus pet is a victory. But winning an acquittal for your clients is certainly a victory for your clients. There's no question about that, and that's what you're supposed to do. But I don't know that it's a great victory for the cause, because at the end, when we question jurors, most of them have no idea what the cause really was. They just know they were sitting down, in our cases mostly like at Westlake Center, or they were doing something at the university, or they were protesting. And that's what the jurors remember. So I do say, as an activist, look for the way to find something to make your message different at the end of the day. Because your message at the end of the day is, I protested, I'm better than you, because I protest and I'm self-righteous and I'm going to take my day in court. And jurors may acquit or they may hang, which is in most of the cases actually. And then we generally don't re-prosecute. So find a way to do it. Don't be so self-righteous to come in and say, I got an acquittal, I'm great, look what I did. Because I guess I've said it 3 times already, and I think listening to people quickly around here, getting a judge to give your clients community service in an infraction is a victory for your clients, but it may not be a victory for the cause. Because in the end, there are a lot of people who are sitting there going, man, they did something really wrong, there should be a price to pay. And frankly, when I was defending protesters 20 years ago, we accepted there was a price to pay for your protest, and part of that price was understanding that you were going to have a consequence, and part of your consequence was either do community service or something, not just abuse the system. Because while you're abusing the system to get your clients off and tie up a courtroom for weeks, there are cases that are important to other people, whether it's domestic violence cases, domestic DUIs, I do misdemeanors, other cases that are being held, and those clients, sitting in jail, waiting for their cases while you're spending a week in a court, tying down a court, for no really good reason. Well, I shouldn't say no really good reason, because I believe in the cause most of the time. But I think you do have to be careful about where you're headed, because what I've seen really is, it's just a protester case.
Thank you.
And could I add a kind of piggyback on that, talking about jurors and what people take away from it? There's, I think, a fascinating development in this case in California with Eric McDavid, and a lot of you might have heard this already. Can you hear me in the back?
Yeah.
Eric McDavid was around the same time of this Operation Backfire sweep of environmentalists. His case involved an informant named Anna that the government paid to infiltrate environmental groups and peaceful protesters. The FBI paid for her gas and her housing and her food, supplied her with bomb-making recipes. She funneled all this to the group, brought 3 people together with her, coerced them into action, of sabotage actions in the name of the environment that never happened. But Eric McDavid was just sentenced to almost 20 years in prison, even though he had not done anything, for conspiring to sabotage and commit actions that were labeled as terrorism by the court.
And if you don't know that case, she was 17 years old and recruited out of a college classroom, and all of the other kids were under 20 years of age. So we're not. She was 17 in a class, did a paper on protest, and an FBI agent approached her and said, "Hey, come work for us. We'll pay you $75,000," which to a 17-year-old was like $1 million. And now she's practically, a near suicidal basket case after the feds used her and tossed her out at the end of the case.
But the reason I brought it up, the tie to this, was after the case, and I think what's a really unusual move, and the room full of lawyers can clarify, a couple of the jurors submitted declarations to the court in which one of them called the FBI an embarrassment. They railed against how they were misled. They didn't know that Anna was on the government's payroll. They thought it was offensive and manipulative that she tried to lead on this kid Eric by flirting with him. He was in love with her, this FBI informant. It was just fascinating to me. Now they've gone on to make statements to the public. They convicted him, obviously. They felt they were misled. And so I guess the point I'm making, though, is to not underestimate people and to not underestimate your clients. And even in the most radical cases like this guy is facing terrorism enhancement penalties for sabotage crimes. And the jurors were absolutely outraged, even though they convicted him. They felt like they were misled, and now they're being, I think, could be instrumental in the appeals process. So it's just something to think about along those lines.
And one other comment I'll make regarding prosecutors, part of this exacerbation of charges against activists, it used to be for most misdemeanor level offenses that people would be ticketed in what's called cite and release, where they'd be given this little ticket, they could pay some money or do some community service and it would go away. But now those same crimes are being charged as misdemeanors or felonies, and so a lot of it has to do with the prosecutors putting activists in the position that they will take up weeks of a court's time. If they would just deal the cases, as infractions, they wouldn't be in court all week. So, I think there's a little of that going on too. In the back.
I have a quick question. Well, we might discuss this a little bit later on, but you mentioned jury nullification. I've tried getting in jury instructions that just kind of verge on instructing the jury on their rationale behind their independence, jury nullification theories. And there's a lot of literature, but generally law schools don't like to really go over that. Your evidentiary professors don't like it. Have you actually been able to formulate a jury instruction that dances or expressly states an argument on how to do jury nullification?
Hell no.
Have you had any luck?
No. And actually, Joyce mentioned the name Howard Lichtig during her remarks. He moved to Oregon, and he was one of my mentors for doing protest cases. He actually took the jury nullification issue all the way to the Oregon Supreme Court, saying that we should have the First Amendment right to argue it. And he was a real big advocate of trying it every time, even though you knew you were going to lose. So no, I've never been able to get an instruction. But when you put your client on the stand, and they can say things that we as lawyers can't necessarily say. And even without using the words jury nullification, I've had trials where the only rationale that I can provide for why my client won was because it was a jury nullification outcome. And you can make some statements in your closing argument that dances close to the line, but doesn't quite cross it. You know, you're not allowed to say those words, obviously, but you are allowed to say that they can use their common sense and their moral compass and, you know, things like that that can kind of imply it without actually stating it. Anybody else? Questions?
I think we're wrapped up on time.
All right, well, enjoy lunch.